Well, we only have one case today that's argued, obviously, and that's Hamrick versus Maloof. And both of you will have 15 minutes. Mr. Callow, you will be able to reserve up to 5 minutes. I don't know, do you want to reserve 5 or do you want to reserve another amount? Or?
I would like to reserve 5 minutes, Judge. Thank you.
I appreciate that. And you know, we're on live broadcast now. And this case doesn't involve children, but ordinarily I tell you not to use victims or children's names. I just kind of like to remind myself to do it so I don't forget as well. And
Yes,
I will keep the time, and I'm ready to begin when you are.
Thank you, Judge. On behalf of my client, we would be asking the court to look at the procedural process in this case, note the numerous irregularities, and return this case to the trial court for a trial on the merits of the case, particularly including the liability issues. As you can see from a review of the file here, this was a series of lawsuits with serious and considerable procedural mess. The case was not determined at any point on the merits as to any liability. What you can see is we have a plaintiff who believes that he was wronged by libel or slander, who prosecuted case number 1 against numerous defendants. That process failed, was dismissed by a magistrate, and then a notice of a dismissal was filed, another procedural strange event. Then it was refiled. Again, it was dismissed against every single defendant except for who now is before the court is my client. It was dismissed for failure to prosecute a second time and failure to move forward with service on any of those defendants. So now what we have, Judge, and what is in before you in this court is a case that has no process whatsoever of a merits hearing against any defendant here. My client gets a default judgment. Again, no process of the merits. And so you have a plaintiff employee who's now given a jury award against somebody who was not his employer and not in charge of him and not an officer of the company, as proven anywhere in the record. It is a strange web of case. My client was present, as the facts read, my client was present at a trial date when the plaintiffs failed to appear. And instead of a judgment of dismissal, he appeared without a lawyer. Instead of a judgment of dismissal, the plaintiffs were granted accommodations by the court. And then the court, noting in the record that he was seated in the back of the trial with the jury, but not seated at a participant table, then engaged in default proceedings against him. Judge, as we indicate, this court has a long history of disfavor for default judgments when a party participates at all.
Counsel, I would just ask you, and I appreciate disfavoring default, but this was a year before he moved to file an answer.
It was, Judge. We would argue that there was not service.
Mr. Callow, we lost you.
Excuse.
We lost your video.
Hello? Judge, we may have to break because I'm not sure he could rejoin automatically. We may have to resend.
Oh, really? Okay.
We might have to. Yeah. Mm-hmm. And some of the Zoom calls, once you leave, well, here he is. Okay, so forget what I said. There we go.
There, we found you again. That's okay.
I apologize for the technical. It clicked off. But Judge, we would argue that he was not served appropriately in the case. I know that there's an indication that Appellee makes that there was service. We believe he wasn't served But at least, Judge, what I think everyone can agree on is that he showed up at some process in the case. Towards the end of the case, when there was an issue of default, he at least at that point retained a lawyer. And at least at that point, the lawyer moved forward with some process. So at that point, I think that those facts are not disputed, that at least towards the end, he did participate at some point. And again, considering the chaotic procedural history of this case, I think that that would be enough to not grant a default and to at least give him a hearing on the merits. Again, the result in this case, Judge, is to have a large judgment again in a case against the person who did not employ this man, and it was not either a manager or an owner of the company, as indicated in the record. It is procedurally, this is just a real procedural nightmare of a case, and to apply the rules in such a difficult manner against Mr. Maloof when they were then liberally given extensions for parties who didn't show up for trial on the plaintiff's side seems to not be in the public policy of this court to say we should not favor default judgments. I just
And Mr. Kelly, you're into your I'm sorry for interrupting you, but you're into your 5 minutes. If you want to break now or continue, that's up to you.
Thank you, Judge. I'll break now and come back in 5 minutes. Thank you.
Thank you. You may proceed. Mr. Burke, you need to unmute yourself. There you go. Thank you.
I just did that. Thank you. Oral arguments during a pandemic. We all have issues.
Yes, that's right.
May it please the court. My name is John Burke. I represent the plaintiff appellee, Mr. Mark Hamrick, in this action. Appellant has failed to demonstrate any errors by the trial court that would mandate a reversal of the jury verdict or any of the trial court's rulings. I want to point out a couple of things initially that the appellant's counsel has stated. He wants to focus on the fact that Mr. Maloof wasn't his employer. This isn't an employment case. It was not an employment case whatsoever. This was a defamation and a defamation per se case. The fact that Mr. Maloof wasn't his employer wasn't an issue in the case. It had nothing to do with the case. It had to do with the employment, had to do with the fact that he lost his job. Secondly, they contend that there is no service. I'm not sure what there's no service of. They concede in their brief that Mr. Maloof was served personally. The record reflects that he was in this matter. There's no dispute about that, and it's conceded in their brief that he was served personally in the case. The second thing that he talks about is that the plaintiff didn't show up for trial or other proceedings, and that's also just a false statement. There was one time where his counsel didn't appear, and it turned out the reason that his counsel didn't appear was because he had become deathly ill and subsequently passed away. That's why counsel didn't appear. The fault is the complaint was filed and no answer is filed. Even when the motion for default judgment is filed, no opposition is filed. They have a hearing in front of the magistrate, and the magistrate grants the motion for default. They attended that hearing. But what they didn't do was at that time seek leave to file an answer, and did not provide the court with any argument even that there was any kind of excusable neglect as to why a full year no answer had ever been filed or attempted to be filed. Subsequently, after the magistrate granted default, they filed objection. And at this point, they filed a document that they called it for leave to file an answer. A couple of very important things in regard to the leave to file the answer. They did not attach any proposed answer. And once again, in this subsequent objections to the magistrate decision, did not make any argument whatsoever as to what the excusable neglect allegedly was. An oral hearing was actually held in front of the trial court on the objections. Mr. Maloof didn't even bother to show up at that hearing. If you review that record, he keeps saying, oh, he should be here any minute. He should be here any minute. He didn't have enough respect for the court to even appear at that hearing. Additionally, no argument was made during that objection hearing in regard to any purported non-service of either the motion for default or the complaint. That argument wasn't even raised. It wasn't even made. So thus, even if they had an argument, which they don't, they would have waived those arguments. Additionally, when you look at the standard of review that this court must apply in regard to reviewing the granting of the motion for default judgment, it is an abuse of discretion. They have not pointed out anywhere where the trial court acted arbitrarily or abused their discretion in granting this motion for default judgment. The reason it was granted is the appellant just ignored the rules, ignored the court, didn't even pretend to try to participate in the litigation. In regard to the other claims that they make, they have a complete misunderstanding of defamation per se. They have argued that no damages were proven. There are two different types of defamation, as you well know: defamation and defamation per se. General defamation, you have to prove your damages. Defamation per se, which was one of the claims in this case, the damages are presumed. So even if they are correct that damages weren't proven, which again, we would argue is untrue, we did prove damages, the jury came back and was specifically instructed on the two different types of defamation: defamation per se and regular defamation. The jury came back and awarded $150,000 in defamation per se damages and $0 in just general special damages for defamation. There is no requirement that any damages be proven. So although we disagree with the appellant and believe that defamation, the damages for the defamation were actually demonstrated and proven through the testimony of both the plaintiff appellee and his spouse, but that we're not even required to prove that in order to sustain the $150,000. Yes, Your Honor.
Counsel, I'm sorry for interrupting. I was trying to wait till you took a breath, but I'm just a little confused because I understand that in defamation per se, you've got presumed damages, but at the same rate, you still have a burden in regard to damages. You can't just come in and say, okay, well, I think I would have earned $1 million last year, and therefore my damages are $1 million.
Well, Your Honor, in terms of the damages from defamation per se, that's why the law, which is very well established in regard to defamation per se, is you don't have to prove specific damages in terms of defamation per se. One of those things is when you're accusing someone of theft. That is defamation per se. The law does not require your reputation from per se defamatory statements. If indeed we were to try to get damages, special damages and specific damages from the defamation per se, we would have to loss of other reputation specifically. And nonetheless, even under that standard, we did demonstrate that. We produced evidence. The plaintiff appellee, he testified that because of this, he lost his job. He testified of the emotional distress that he suffered as a result of these defamatory statements. He had spent his entire career in this field, and then he was accused of stealing from his employer. Now, it's a little disingenuous to contend that Mr. Maloof didn't have anything to do with that company. His wife actually ran the company, and he behind the scenes actually ran the company. But has all sorts of other judgments against him, so he couldn't actually be an employee. But there is a difference under the law, defamation per se, no specific damages have to be proven versus regular defamation. But once again, we would argue that we demonstrated both. Additionally, they contend that they have received no due process, which is they have had every opportunity to defend the case, chose not to defend the case for a substantial period of time. And then when they did defend the case, barely put on a defense. Mr. Maloof didn't even testify in his own defense. And interestingly enough, the appellants tried to argue that, well, we couldn't comment on the fact that he didn't testify. But this was a civil case, not a criminal case. The other evidence that they put on were from
you could have called him too.
You are correct, Your Honor.
Mhm.
You are absolutely correct, Your Honor. We didn't feel we needed to call him because we were proving damages, defamation, and defamation per se. But nonetheless, the granting of the default judgment in this case was entirely proper because he had a year to answer the complaint and then didn't even attempt to answer the complaint once the motion for default was filed. He filed no opposition to the motion for default. He did not ask the court at that hearing if he could file an answer, demonstrate some kind of neglect, didn't even argue any kind of neglect. And then even when the magistrate issued its ruling at the objections, the same thing occurred. Once again, they just said, well, you should let us answer the complaint. But if you read the motion that they filed, they demonstrate no neglect. They didn't even attempt to argue. They provided no excuse. Quite frankly, at no time throughout this entire litigation have they ever provided any kind of rationale, excuse, explanation for why they never filed an answer or never even attempted to file an answer.
Counsel,
We believe
it's a little unusual as well on the plaintiff's side, I mean, on the defendant's side as well, in regard to the default judgment. There was no, on the plaintiff's side, there was no motion for default for a year too.
That is correct, Your Honor. And a lot of that had to do with the fact that he had gone through a couple of lawyers. One passed away. I wasn't counsel at that time, so I don't know what happened prior to that. But nonetheless, the courts on several occasions noted that service had occurred. And then subsequently, just like 10 days before the scheduled trial before the magistrate, they did file a motion for default judgment. It was properly served. The docket reflects everything was properly reserved. And the defendant just failed to participate, failed to answer that complaint, even when given an opportunity, and failed to even attempt to do those things until after the default was granted. We believe that there were no errors by the trial court. There was no abuse of discretion in regard to the granting of default judgment. That's the standard that this court has to apply, not an error of law, not a mistake of fact. It's whether or not the trial court abused its discretion. And that standard is very high to overcome for the appellant in this case. You have to some way acted arbitrarily. Still to this date, they've not explained why they didn't answer. They haven't explained, yes. Yeah.
Counsel, what effect does a limited participation of Mr. Maloof have on that default judgment? You know, he was seated in the jury pool, showed up for the trial, albeit seated in the jury pool. Attorney entered an appearance, filed a motion to continue the trial. How does that affect our evaluation of the default judgment and the fact that an answer wasn't filed?
Oh, let me address first the seated in the courtroom thing. And again, I wasn't counsel at that time. That when I went back and read the record, I found the whole thing shocking that he would not identify himself. He was kind of just surreptitiously had put himself in with the jury, apparently. And at that point in time, he still hadn't filed any kind of responsive pleading, apparently didn't have counsel either. But that occurs initially, and the court actually was going to start this trial and then finds out that Mr. Maloof had snuck himself into the jury pool and decided that the case had to be mistried, had to issue a mistrial. So then the subsequent action was after the motion for default was filed, as the case had been reset for a trial on March 25th. And he files a motion to continue, I think just before that date. The court doesn't really rule on that. The court just granted the motion for default judgment. But that's not an abuse of discretion after years of kind of thumbing his nose at the court and the system.
Remind me, did the court have a hearing on the motion for default?
I believe that there was a hearing. I think that the docket reflects that it was on March 25th. That was held by the magistrate. And then subsequently, objections were filed and another hearing was held, this time in front of the actual trial judge, not the magistrate. At that subsequent hearing, Mr. Maloof, once again, did not appear. And the trial court noted that they hadn't presented any evidence of excusable neglect as to why they hadn't filed any answer or even requested to file an answer. The first time they requested leave to file an answer was after the default had already been granted at a hearing that they attended. There is no abuse of discretion in this matter. I see that my time is almost up.
I was just going to tell you, just have a few seconds left.
Thank you, Your Honor. Review the record and sustain the jury's verdict. There were no irregularities that would mandate reversal. There was no abuse of discretion. And I think that
I'm so sorry, counsel. Hold on just one second. Okay. Now, you were saying there was no abuse of discretion?
Yes, thank you. There's no abuse of discretion, and this court should affirm all the rulings of the trial court. Thank you for your time.
Thank you. And Mr. Callow, you do have your 5 minutes remaining.
Thank you, Your Honors. I'd like to briefly address a few things. First of all, the second error in this case to be briefly addressed was that the plaintiff failed to produce any discovery until the morning of scheduled trial. The judge then facilitated the production of those documents, refused to grant a continuance, and the defendants were forced to go to trial with basically a scant production of the evidence and discovery, as well as very limited time in advance to review those documents. We believe that's an abuse of discretion by the trial court that alone would warrant a new trial. I mean, that's not how we do trials by a shotgun anymore in these cases.
Excuse me, counsel, just quickly on that. The other side is arguing there was no objection to the trial proceeding, therefore that's a waiver of that issue. How would you respond to that?
I would say that defense counsel on the morning of trial did ask for a continuance due to the discovery violations, and that was denied by the judge. And I believe that denial would be an abuse of discretion.
All right.
I would also, thank you, Judge. I would also like to quickly point out that in the defamation per se, the argument is that damages are presumed, but there must be some relation to the evidence presented with the jury's verdict finding. In this particular case, not only is Mr. Maloof not his employer, and therefore it is odd for him to be responsible for lost wages, but the plaintiff testified in his own testimony that he was not seeking employment after his termination because he was voluntarily watching his granddaughter. He then also testified that he had an opportunity to be reemployed with this employer that he denied. He testified he thought it was part of a negotiation strategy, but he denied being reemployed. He also testified that he had opportunities at other times to be gainfully employed and did not take those jobs. And then he did say that during this time period, he did, in fact, receive employment, and there was no offsets for any of the employment wages that he received during that time. And we believe that there has to be some relationship even in a defamation per se case, there has to be some relationship between the evidence and the dollar amount awarded by the jury. And in this case, we believe that there was no relationship. And again, then circling back to the first argument, clearly, as this court has pointed out in some of its questions, my client at trial did participate in some of the process. He retained a lawyer. He asked for discovery. He filed a motion to continue, saying he did not have enough time. He appeared at trial, and yet he's never been given an opportunity to defend the case on the merits of the case. In fact, at the short hearing that was had in this case, there was no references even to what Mr. Maloof allegedly said to even allegedly slander. So in the end, we're left with a procedural mess and a jury that's being instructed to award some damages based upon a claim against a person who they don't even know what was said or what were the details. And then they're being told to award something because it's pro se, but there's no relationship to the number that they provide and to the alleged damages that were asked for. Judges, in this particular case, it's clearly a procedural mess, both at the hearing, prior to the hearing with discovery, and the mess that occurred before it. We would ask that you remand this back to the trial court and instruct them to have hearings on the merits of the case and let these parties have a hearing on the merits of the case to determine what and if those damages should be in a fair process. And we would ask you to do that. Thank you, Your Honors. My time is up.
Thank you. Gentlemen, thank you both for your presentations to the court. I appreciate your arguments, and we will obviously take the matter under consideration, and then we will issue a written opinion that will be sent to both sides from the clerk of courts. And you both know that you can also look on the Supreme Court website and our website in regard to the opinions.
Yes, Your
Okay.
Honor.